I am delighted to be with you tonight. Thank you so much for your invitation from the board, from Mark, from Ann, from all of you. It's a special opportunity to be with you tonight. To do some civics with you, I promise it won't be too much law school, but hopefully we'll get through a lot of information tonight in the area of rule of law, some of the constitutional challenges that are going on these days in America. And it's important for me to state right at the outset that our discussion tonight, as it always is, will be nonpartisan, non-political, but I'm also at the same time going to identify issues that every American, regardless of your political persuasion, wherever you are on that broad spectrum of things, should be concerned about, should be celebrating in America. We'll talk about some of those challenges, and then I promise you that during the course of our discussion tonight, we'll also give you some reasons to do some things as a part of your civic responsibility and to engage in government in a way that all of us want to do. So once again, thank you very much. The other thing I will say at the outset is, I repeat this a lot, it's a lot. There is a lot of material going on, and indeed, as we were gathering together just tonight, another news item that's relevant to what we're talking about this evening in connection with the powers of the government. We'll talk a little bit about that. So there's a lot of material tonight. I hope that I know that you will stay with me for all of that, but I also hope that if you have questions along the way, you store those away, because we will have an opportunity at the end to do just that. Again, thank you so very much for all of this. You know this as well. I don't need to talk to you about this at all. You know the three branches of government. If this were a 4th or 5th grade class, we would go through that. But it's important for us to understand, as we always should, that these three branches are still obviously the foundation of our nation. They're the basis upon which our Constitution is built. And operationally, from day to day, these are the expectations that we have. A legislative branch that passes laws, an executive branch that, according to James Madison, who put together the Constitution, 1787, passed ultimately in 1788 and 89. The notion is that the laws that the Congress passes, the House and the Senate, are then executed by a president at the time, the first time on the face of the planet that there was such a person who wasn't a king, responsible for bringing into effect the laws that the legislature puts out there. And then, of course, we also have a judiciary that's responsible for interpreting. Let's do that. For interpreting, very good. Thanks, Nolan. For interpreting what it is that the legislature enacts and how it is that the president may, in fact, be executing those kinds of things. And so tonight's very broad agenda, it's a lot, once again, hold on, is going to be talking about checks and balances under Article 1, which is the legislative branch, that commissioned by James Madison. We'll talk a lot about Article 2, which again is the executive branch. That's the President of the United States of America. And then also necessarily through the lens of our Supreme Court and our federal courts, we'll talk about Article 3 of the Constitution. Again, a big agenda. It is ambitious, but we can get through it together. And again, we're looking forward to that discussion. One of the things that people often ask me at the outset is what kinds of things are out there right now that are ensuring that our government still stays in place and that there are the checks and balances that are a part of our system. And I would offer to you at the start of our discussion this evening that there are at least 3 and maybe 4 of them that are out there. We will talk a lot tonight about federal district court judges. I'll explain who they are, and that they are issuing decisions, again, including as late as this past week, on major issues that are coming out of the executive branch in particular, but also invoking, in some ways, the legislative branch. We'll talk about the fact, again, that federal trial court judges are issuing, as you know, lots and lots of opinions these days that do affect our lives right here in Waupaca, throughout the state of Wisconsin and beyond. We'll talk about federal grand juries that have this all-important role under our Constitution to decide what kinds of cases will be prosecuted, which kinds will not. You have heard about some of their activities in recent days. I spent most of my 30 years in government appearing in front of federal grand juries, presenting to them evidence of criminal conduct. In the end, here's your first civics point for the night. The federal grand jury is the only mechanism in our Constitution by which an individual here in Wisconsin, in Waupaca County, throughout the United States can be charged with a federal crime. United States attorneys do not have that capacity, with the exception of a very, very narrow area. Attorneys general do not have that responsibility. Presidents do not have that responsibility. Grand juries, they are you. There are 26 people. There is one grand jury, at least one, in every single district in the country. I'll show you a map in just a moment about that. And they meet and they hear evidence, again, not in the public domain, privately, about crimes and criminal activity presented to them. And they're the ones, you are the ones who determine what cases will be indicted and which ones will not. They are also these days part of the check, yes, on the executive branch, partly also on the courts. The grand juries are components of the court system as well. And the final thing that I will say, again, regardless of how you may be interested in advocating for your particular position, the notion of public advocacy in all directions is important, and it's also critically important, not only as we talk in recent days and weeks a lot about the First Amendment and the capacity, again, of all Americans to be heard. Congress shall make no law affecting the right of the people to speak, to advocate, to seek redress of grievances before their government. No restrictions on the press, and of course, as you'll see in just a moment or so, other aspects of that First Amendment. And so these are the kinds of things that today, even as we talk about some of the challenges that I would offer to you, should be concerns for every American today. All of these things are still in place. And that is very good news about America, and each one of us should be very proud of that fundamental notion. So one of the things we're going to do tonight is understand some of those checks and balances through the lens of the United States Supreme Court. You know the court, they've been kind of active. They've been taking a lot of the press, if you will, and getting a lot of attention these days, including just a couple of hours ago. We'll get to that in just a few moments or so. I'm going to tell you a little bit about the statistics of the present court term, which is concluding in about 2 weeks from yesterday. We'll talk a little bit about the merits docket. I'm going to explain to you what that is and give you some sampling of the wide variety of cases and decisions and topics and challenges that the Supreme Court is deciding today that affect your lives every single day. We'll raise in that context the question of this balance of power, and whether you can decide this, whether the legislature should be making some of these decisions as opposed to the courts. What is the balance there? And then we're also going to talk about a very important part of the process, which is the emergency application or emergency injunction docket, sometimes called the shadow docket. We'll tell you about what that is. And I would offer to you, again, it is a reason for every American, regardless, again, of your political persuasion, where you come from, historically or presently, it is a reason for you to be concerned about the ways in which major decisions are being made by our courts at the highest level and others as well. And then we're going to talk about some basic themes and perspectives that I would offer to you, kind of in conclusion for all of this wild ride in which we are now going to go. You know those folks. Again, if I was speaking to fourth graders, they would not know them. I'm guessing if we did a quiz right now, every single one of you could give me the names of every single one of them. I promised Mark, I promised Ann that I would not be doing a quiz during the course of our presentation tonight. So I'll give you the answers, and you know them well. These are the 9 members of the Supreme Court. We're going to talk about a lot of the things that they have done. You'll see some of the things that many of them have said in some of these major cases. Let me identify them for you. Down front, those are the seniors. Those are the people who've been there a long period of time. In the middle there, that's John Roberts. He's the Chief Justice. I'll make reference to him a lot tonight. To his left, our right, that's Sam Alito. And to the right of the Chief Justice, to our left, that's Clarence Thomas. And then you go to the far left, that's Elena Kagan and Sonia Sotomayor down front. Those are the most tenured justices on the Supreme Court right now. In a couple of years, Clarence Thomas is going to be the longest tenured justice on the Supreme Court in American history. Significant, right? For what it's worth, Elena Kagan is the only Supreme Court justice who was not previously a judge. And if you question me afterwards, I can tell you where all of them come from. Many of them from the courts of appeals, many of them from the D.C. Court of Appeals, and that brings me to the second row. These are the freshmen and the sophomores, if you will, on the Supreme Court. Left to right, that's Amy Coney Barrett. I will explain to you that she is our Associate Justice, and so if you have a particular application of an emergency nature, you need to get to the Supreme Court very quickly, you call up Amy Coney Barrett and say, Amy, we need to get on your docket right away. She is the one assigned to the Seventh Circuit, which we'll talk about. To her right, that's Neil Gorsuch. He comes from the 10th Circuit Court of Appeals. To Neil Gorsuch's left, that's Brett Kavanaugh. He comes from the D.C. Court of Appeals, as does the person to his left. Her name is Ketanji Brown Jackson. And they, once again, they're the younger members, if you will, of tenure on the Supreme Court. I jokingly say that because she is the least tenured, when they get together and fight about decisions that we'll talk about tonight, Amy Coney Barrett is the one who has to go to the door and pay the pizza guy as they deliver the food for the discussion that evening. That's the Supreme Court, and again, we're going to be hearing a lot about them tonight. So it's important, Ann and I were chatting about this before, to get some sense about where these cases come from. There you see the United States of America. As you know, it's not in colors, they're not big numbers all over our nation, but there you see that we are in the Seventh Circuit, and in particular that Lyme area. We are right now, again, obviously here in Waupaca County. You're a part of the Eastern District of Wisconsin. And so before, when I jokingly said, in response to Mark's great introduction here, that all of you were at one time within the jurisdiction of my office in Milwaukee and in Green Bay, in fact, you are. And so to this day, if you have civil complaints of a federal nature, and this won't happen, but if you are a defendant in a criminal case, you will come to the district court in Milwaukee or Green Bay. And significantly, you should note that it is the 28 easternmost counties in the state. If you go to Portage County, just immediately to our west, you're in the Western District. Keep that in mind for something I'm going to talk with you about in just a few moments or so. If you are dissatisfied with the civil or the criminal litigation that comes out of Milwaukee or Madison or Green Bay, where do you go? Well, you know, you can appeal something, right, in the federal court system, and then you go to the Seventh Circuit, that's where that number 7 is, happens to be in Chicago. And so you go there and you argue to the Court of Appeals. There was recently a judge that was reviewed by the Senate Judiciary Committee, and she is going to be taking her position fairly soon upon a full vote of the Senate in the Seventh Circuit Court of Appeals. If you are still dissatisfied with what the appellate court does in resolving your case, where do you go? You go to the Supreme Court. And that situation gets repeated thousands of times every single year. Needless to say, as you'll see in just a moment or so, the Supreme Court does not take every case from every single district around the country. They couldn't possibly. I'll give you the number in just a minute or so. But the reality is that's the process, and whether or not you are in the Seventh Circuit, if you're in the Ninth Circuit, we'll hear from them a little bit tonight, the Fourth Circuit there, the Mid-Atlantic states, Fifth Circuit, Texas, Louisiana, Mississippi, all of those districts, all of those appeals courts feed into the United States Supreme Court. Here's your Latin for tonight. If, in fact, the Supreme Court decides it will hear your case, criminal or civil, they will grant what's called a writ of certiorari, okay? There's your Latin, writ of certiorari, and that means basically the Supreme Court will take your case. The great majority of people who are seeking review of the appellate courts and the district courts are disappointed, and they do not get Supreme Court review. They simply have to be resolved to take the decisions of the lower courts. The other circumstance, of course, in which you can get to the Supreme Court, we know it here in Wisconsin because it's happened not too long ago. If the Superior Court, the top court in a particular state, also issues an opinion, the Supreme Court can take decisions from the highest court in any particular state. And we saw that here in Wisconsin when the United States Supreme Court, particularly in terms of voting cases, election matters, reviewed a couple of years ago some of the cases coming out of our Wisconsin Supreme Court, a state court process. But the federal courts are the ones who most often bleed into and produce all of the cases for the Supreme Court. Here are your numbers. The Supreme Court, in the term that actually is still concluding right now, we're still in the 2024-2025 term for a few more days, decided a whopping 60 cases
60 cases out of probably thousands of people who wanted to appear before the Supreme Court. They conducted oral arguments from October until April, and most of those cases were from the courts of appeals in the Fifth Circuit, again, as we saw, the Fourth Circuit, the Ninth Circuit produced a number of them. Only two cases came out of our area, the Seventh Circuit, and I'm disappointing you once again. We're not going to be talking about those tonight because there's some other things that I think are perhaps a little bit more relevant, although every single case out there is important. You can go online, type in the United States Supreme Court, and you can find the decisions on every single one of those cases from this term and from any of the past terms of the Supreme Court. It's accessible to you. Here's another piece of information. As the Supreme Court goes into its next term, which it starts literally 2 weeks from today, they're going to have the first oral arguments. You can listen to all those justices, argue with the attorneys, argue with each other, talk about the cases online. You can't see them because there are no cameras in federal courts, but you can hear John Roberts and Ketanji Brown Jackson and other justices argue with the parties. You can hear their voices live, and you can also hear their arguments recorded. Let's talk about what I think are two of the major cases, two among the 60. So I'm excluding an awful lot right at the start. But I wanted to talk about these two in particular for a couple of reasons. One is they're all over the headlines. And second, because they're important lessons about the ways in which our government, and in particular judges and justices, work today. You know that because, again, you are involved in high school and college civics. That's the 14th Amendment to the Constitution of the United States of America. 1869, passed among the Civil War amendments. And this is the language that we often talk about a little bit tonight, but not a huge amount. This is the place that you get all this language about privileges and immunities. This is where you get no deprivations of life or liberty or property without what? Without due process. This is where you get the concept of equal protection of the laws. All of those things that we normally think about as being fundamental to our nation comes from the 14th Amendment. It's also found in the Fifth Amendment to the Constitution, but the 14th Amendment is the one that gives us all of those concepts. And usually, when the Supreme Court justices talk about these kinds of principles, and the 14th Amendment in particular, they're looking at that language. The reason why this case is so very important, and it's called CASA, C-A-S-A, is because although it's been out there in the past, for the first time this calendar year, our nation has been focused upon not that other language in the 14th Amendment, but the first portion of the language in the 14th Amendment has to do with citizenship, right? Who is a citizen in the United States of America? And the language reads, anybody who's born or naturalized in the United States are citizens of the United States of America, right? And you're saying, but wait, Jim, wait. There's a phrase in there that you did not say out loud. And yes, indeed, there it is, subject to the jurisdiction thereof, okay? Since 1873, the United States Supreme Court, in a case involving a Chinese family in California, has determined that it is the law, it is the constitutional premise of our nation, that if you are geographically born here, if you are on the property of the United States of America, voila, you're a citizen, all right? And that has been the law of our nation probably before 1873, but affirmed by the Supreme Court, again, a bit over 100 years or so ago. And so what happens in this particular case, it is on January 20th, when President Trump first becomes our president, he issues one of his many executive orders. And we'll talk a lot about those tonight as well. And among those is an order in which he says, I'm going to seize upon that language, subject to the jurisdiction of the United States of America. And the executive order says that for babies born in this country, basically it's from mid-February until presently, for all of those babies, those newborns in the United States of America, geographically born in Wisconsin, in California, in Guam, in other places around our nation, for all of them, they will be citizens except if your mother or your father was illegally here or here only temporarily. Illegally here or here only temporarily. That's the predicate for what the president did on January 20th and said that if you are the son or the daughter of someone, not properly here legally, here illegally or temporarily here. Therefore, here's your legal stuff again. Therefore, your parents and therefore you are not subject to the jurisdiction of the United States of America, and for that reason, you are not a citizen, okay? And so what happens is that people obviously identify this as a significant change in what the law has been. It's an executive order. It's not a legislative enactment. And what do? What do Americans do? What do they do with respect to all those district courts we just looked at? You go into court. And there are district courts in New Hampshire, the entire Ninth Circuit, that big area we saw in the western part of the nation in that map. There are courts around the nation, including those two, that basically say that the president's executive order is wrong, that it's not, in fact, a proper articulation of the Constitution. They go back to the Supreme Court precedent of 1873 and say, no, it doesn't matter what your mother or your father's status was. If you were born here geographically, you're a citizen. And what happens, of course, is it percolates up through the courts of appeals across the country. Eventually, the Supreme Court, in the springtime of this year, grants one of those writs of certiorari and says, we got to resolve this. This is a big issue for America. So come to the Supreme Court and argue with us about whether or not the president is right or wrong. Are these lower district court judges and appellate court judges right? Or is the president right in invoking that language of the 14th Amendment? And during the course of oral argument, even before that actually, the Supreme Court surprised all of us back in April, because at the time the Supreme Court announced, you know what? We're not going to decide that issue. We're not going to tell you what the 14th Amendment means. Instead, we're going to be concerned about something else that's going on in America, and that is that when those judges in those various district courts around the nation are issuing these opinions, finding that the president's executive order is unconstitutional, they're doing what's called a nationwide or universal injunction. They're making their orders effective beyond the particular jurisdiction in which they are. And so here we are in eastern Wisconsin. Suppose you have a judge, Milwaukee Madison, who says, you know, I agree, those babies should in fact be citizens of the United States of America. And I'm making that decision not only here, but I'm making it for all the other districts throughout the nation. Everybody else has to comply with this as well. That's called a national or universal injunction. And we could spend the entire hour talking about them. There are merits and demerits of that. There are rational arguments in favor and in opposition to doing that, as you can well imagine. The Supreme Court, when it entertains these oral arguments in the springtime, says, you know, we're not going to decide the issue, but what we're concerned about is you've got a judge in New Hampshire who's entering an order and saying the president's executive order does not apply in Southern California. Is that right? Again, other circumstances when that has been done, but is it right to do here? And Amy Coney Barrett, again, there you see her in that sketch. Again, we've got sketches because you can't, a video or you can't film the Supreme Court. She is the one during oral argument who basically says, you know, I think there are some circumstances where, yes, indeed, there are some nationwide constitutional things, First Amendment stuff, Second Amendment stuff, Fifth Amendment, Eighth Amendment stuff, that should apply across the country to everybody, right? And just because a federal district court judge says it in this district means that probably it's right, and therefore it should apply broadly. But she says there are other things that probably don't have that kind of a regional or broad application, and it may be things, for example, that happen in Waupaca County. And as wonderful as Waupaca County is, the reality is it may not have an application in Los Angeles or in Montana or in South Florida. And so she says we got to come up with a rule that sort of gives lower judges a sense of what this is all about. And there are an awful lot of people, me included, who looked at this and said, Amy Coney Barrett, you probably have it right. Find out that kind of middle ground where we should all be in America and go with that. She surprises us then, what I think is the most significant case in this term, by doing this. And she says in particular, 6-3 majority, and I'll identify those who are in the minority in just a moment or so, that all this universal injunction stuff, the situation where a judge in New Hampshire declares what the constitutional principle is and it applies across the board to everybody in the United States of America, that's not right. And she surprises everybody by not articulating this kind of middle-of-the-road rule. She says, you know what? The Congress never granted the authority of federal district courts to act this way. Note once again, James Madison's constitutional stuff. It is indeed the Congress that establishes not only that map that we saw before, but the jurisdiction of our federal courts. And she says, I'm looking around and I do not see the Congress giving a single federal district court judge or even one larger appeals court the capacity to do these universal injunctions. They're wrong. And she also looks to history. She says there's nothing at the time of the founding would likewise suggest that. And so the Supreme Court says no more national injunctions, not just for the 14th Amendment and birthright citizenship, but for any other issue in America. And I'll get back to that in just a moment or so. That is a significant, regardless if you think it's right or wrong, that is a significant change in the way that your federal judiciary works, and it happened just months ago. It is a significant departure from the things that the federal district courts and the appellate courts have done. Does the Supreme Court announce things that surprise us? You bet it does, right? On a regular basis, there are probably things that you agree with, things that you disagree with, but they do this regularly, and they establish what the process is for the lower courts to work. Here they basically said, this national injunction stuff has got to stop. And she recognizes at the same time when she writes for the majority here that because this is a huge change in the way that courts work in America, she says, you know what? Because of that, and because of the underlying issue related to birthright citizenship, we've got all these babies born since February up until late June and even beyond then. I'm going to give everybody 30 days to figure out what the status is of all of these babies who are still babies in America just in the past several months. So she gives them 30 days. And she says something else that's very, very important. She also says that while we're taking away this notion of a national or universal injunction, there are other remedies that are still out there. District court judges can still enter orders as to the parties who are in front of them in the Eastern District of Wisconsin, in the District of New Mexico, in the Eastern District of Virginia, that kind of thing. But they can also do something else. They can impose what are called class action judgments. Class actions are still available to you, right? Now, I'm going to be a little bit flip about this and tell you, you know what class actions are. It's when you buy a lawnmower or an appliance, a refrigerator, and you get a letter from typically a lawyer who's saying, we're suing that company because there's something defective about the thing that you bought, and if you'd like to be a part of this class action, where we're going to try to get some money for you, you can do that. Check the box and send the card back in. And what do we all do? We all do that, right? You send the card back in and you forget about it, right? And then 3.5 years later, you get a check in the mail. It's for $4.53. And they say, congratulations, you're a part of a class action. We have now remedied that problem. I'm being very flip about that. Class action litigation is very important in this nation, but that gives you some sense about what happens here. And so Amy Coney Barrett says, no more national injunctions, give you 30 days, and oh, by the way, there's some other remedies that are out there. Significantly, once again, in the opinion on June 30th, the last day the court is issuing these major decisions, the Supreme Court goes on to say, once again, we are not deciding, believe it or not, whether or not the president is right or wrong. We're not deciding that. We're not deciding birthright citizenship. We're simply saying no national injunctions for any judge, Milwaukee, Madison, Green Bay, that might determine the citizenship of these babies. Now, needless to say, there are 3 people in the Supreme Court. We'll see them in other situations tonight. They are Ketanji Brown Jackson and Elena Kagan and Sonia Sotomayor, and they are all in wild opposition to what the majority has done. This is where you get the 6-3 majority. As you know well, if a majority of the Supreme Court issues a decision and a majority of its members concludes it goes one way or the other, that's the law. And yes, indeed, associate justices routinely, we'll see that a lot tonight, associate justices will often write this kind of language in which they say the majority is completely wrong. And let me tell you why it's wrong. So you've got here, for example, Sonia Sotomayor saying that the president has made a mockery of our Constitution. Obviously, the majority disagrees with her on that. And also note that it's in this situation, too, where Ketanji Brown Jackson writes on this. She is opposed to what Amy Coney Barrett has written. And you may have seen some of the news about this. One of the other themes we'll talk about tonight is the overt disagreement in the public domain they're fighting with each other these days about who is right and who is wrong. And you probably recall some reporting that Amy Coney Barrett talks about Justice Jackson being simply wrong on these issues. She identifies her by name. And Ketanji Brown Jackson, if you will, returns in the same tone and says, no, you're wrong about this. We've got sparring going on in the public domain in this and some other cases as well. So, again, you've got Ketanji Brown Jackson. You can see the kinds of things that she says. She says, you know, the problem here with what the Supreme Court has done in taking away the notion of universal injunctions is that it robs the citizens, residents of the United States of America, from the possibility of getting a decision in some of these major areas like constitutional dimension issues that would otherwise be applicable across the nation. And talks about how, again, in very strong language, majority forgets that the judiciary has a role to play here, and what you're doing is you're basically saying that the courts, in fact, if we are the last ones standing here, we are the ones who have to stand up and push back on what the majority is saying. You can read all the language here. I encourage you, as I often do, to read the majority opinion, read the dissenting opinion. You will see this language in there. Again, 6-3, the issue is no more national injunctions. And so what happens is, okay, we go back to these district courts. I mentioned New Hampshire before. Here is Judge Joseph LaPlante. I'm guessing you've never heard of him before. I never heard of him until not too long ago. Joseph LaPlante says, all right, I've got a lawsuit in front of me on behalf of some of the babies born, again, in New Hampshire, but in other places. And since the Supreme Court hasn't decided whether or not they're citizens, I will do just that. And I will do it not by imposing a national injunction, because Amy Coney Barrett and the majority said he can't do that. What I'm going to do is I'm going to certify a class of all of the children born of mothers, fathers who are not legally here or here temporarily, and I'm going to identify them nationwide. That's the class I'm certifying, and as to all of them, congratulations, you're all citizens, okay? And others do it, right? You've got Deborah Boardman, she's in Maryland. Leo Sorokin, he is in Massachusetts. Others are doing those kinds of things. They're seizing on the language and saying, we can't do national injunctions, but we're going to do a class action, and we're going to accomplish the same thing, okay? You're probably looking at me and saying, Jim, is there really any difference in those? And the answer is there really isn't, right, in the end, because what Judge LaPlante did is he identified this large group of people nationwide in his class and granted them the same thing they otherwise would do under a national injunction. Needless to say, this gets the president and his counsel and the attorney general and your Department of Justice very upset, right? Because that wasn't their intent, right? And what you've got now are district court judges who are saying the president's executive order is illegal and unconstitutional, and they're seizing upon this language from the majority opinion that apparently permits them to do that. You should know that the Supreme Court, again, upon the petition of the president, in the wake of what all these judges are doing, almost universally nationwide, finding that these babies are in fact citizens, have petitioned the court again and asked, please, please take up this decision that you didn't take up the first time around. Tell us what the 14th Amendment means. And that's what we've got to look forward to in our future, right? The next term that begins again in 2 weeks from now, they're going to be discussing that. This issue is still unresolved, but the point of the reason I'm bringing this up is the significance, yes. Is it significant for those babies and others born in the future, whether you're a citizen or not? Should the law from 1873 be overturned? Should we have a new principle that we have not had before in our nation? Or should it continue to be the tradition, frankly, pretty much since our founding? That's the issue out there. The larger issue is this. Putting aside the importance of birthright citizenship, this notion that now, if you have a constitutional or other issue to resolve and you want to challenge it, you here in Waupaca, I'll drive you back down tonight. We can go into the federal court tomorrow morning and file your petition there in Milwaukee, or we can go over to Madison, or go over to Green Bay and do it. And you may get, on behalf of maybe, I'm going to guess, maybe not your children, but maybe your grandchildren, maybe some of you got great-grandchildren who are babies right now, Probably none of you falls in this category, but if you know someone who is the child of someone who is illegally here or here just temporarily, they may still go into court and ask for their citizenship to be addressed. And so what would you do? You'd go to Milwaukee, which is the federal courthouse. I suspect many of you have been there. And you would say, Judge, make a finding, as these other judges have, that this particular 4-month-old, because he or she was born geographically in the United States, in Wisconsin, other places, is a citizen. And you know what could happen as a result of this decision of the Supreme Court? The judge there, again, makes a decision, yes or no. Let us suppose the judge says, yes, I'm going to go with the Supreme Court precedent, which is still the existing law in our nation, and I'm going to find that that isn't indeed the situation for your particular infant. That applies now in the Eastern District of Wisconsin, including Waupaca County. If you drive, how far away is Portage County from here?
5 miles.
5 miles. And if the judge determines, Mark, that your great-grandson, again, wouldn't be your legacy here, but determines that the baby is a citizen in the Eastern District of Wisconsin, that decision does not apply 5 miles away from here. Because you can go into the district court in the Western District of Wisconsin in Madison and get a same disposition there. But if you want to go to Chicago and you need clarification on that, you need to go then to the U.S. District Court in the Northern District of Illinois. You fly out to Manhattan, you need to go to the Southern District of New York. You need to go to every single jurisdiction to get the relief that Amy Coney Barrett said you've got to get. No more national injunctions, no more applicability of your singular order here in Eastern Wisconsin applying across the board. And that's why an awful lot of people are looking at this, not just with respect to birthright citizenship, but the need now on some of these major issues to go into individual courts around the country. I can go on about this. You can imagine many, many different situations not related to birthright citizenship where a president in the future may declare something constitutional right or deprive you of a constitutional right of some kind in order to get that vindicated in your particular place of residence. Yes, you can go into the federal court, but if you travel around the nation in order to get that same affirmation of whatever the right is, you need to go into all the different federal courts. And that's the criticism that Ketanji Brown Jackson also articulates. I would offer to you, regardless of how you feel about birthright citizenship, the 14th Amendment. And again, we live in a wonderful country, right? Where I can stand in front of you on this wonderful Monday evening and speak critically, candidly, about the implications of what the Supreme Court has done. Amy Coney Barrett and the Chief Justice would be here. You should invite them in some time, and they will come and they will tell you that Jim Santel is completely wrong. That's also a part of our nation, right? And we embrace all of that. But it's important for all of us to recognize the great power that our Supreme Court has on something that seems very wonkish, very down the rabbit hole, that affects every single person in our nation. And they did it on June 30th of this year. Let's talk about one other case and then move on. I'm going to be a little bit brief here. This, of course, is the First Amendment. I talked about it before. This is a religious case. It's got something for everybody to love and something for everybody to hate. This comes out of Maryland. It is Baltimore. It's the biggest academic school area in the state of Maryland. And as a result of some changes in their board-approved curriculum, they introduce, in a small way, some exposure to LGBTQIA issues in everything from kindergarten up until the 12th grade. It's a small portion of the curriculum, but among other things, there's some storybooks that are presented to second and third and fourth graders, and there they are. You can actually read one of them called Uncle Bobby's Wedding. It is attached to one of the Supreme Court decisions here, so you don't even have to go out and buy it. But in the end, what happens is that a group of parents in Maryland come forward, and they say that my religion, my faith, tells me that I do not want my son or daughter, again, this is in the public schools, very important to underscore that. The public schools do not want my son or daughter to be exposed to that kind of storybook narrative, other things in which there are same-sex couples who are leading a family, okay? And they say, my religion tells me that, and as a result of that, I have a right, a constitutional right, to have my child withdrawn from the school, the public school, or the classroom for that period of time when that particular instruction is going on. It's religion, as you can well imagine. It relates to academics, right? For those of you who are teachers, I suspect many of you are also thinking about the implications of this for that. It relates to the curriculum adopted by the school board. It relates to parental rights, right? All kinds of things wrapped up in this. And the reason why I identify it, once again, is because of the impact of it. That's Sam Alito. He writes for the majority. Once again, a 6-3 majority. It's the same majority we saw before. You'll see that repeatedly tonight. And he says, again, the Fourth Circuit, before it comes up to the Supreme Court, says no. These particular storybooks, they're pretty innocuous, and they're not doing what the parents said here, which is proposing transgender ideology among second graders and all this kind of thing. The Fourth Circuit says there's nothing about this instruction that promotes gender or sexuality in a way that the plaintiffs allege, and they deny that there is any violation of the religious liberty in the First Amendment. Comes up the Supreme Court, a 6-3 majority goes in just the opposite direction and says, no, that's not right. That you can read the language there. This is coming from Sam Alito, and he writes an opinion and talks about how there is divine creation and that sex and gender are inseparable, and because of that, there is a religious right. There is a religious investiture in the First Amendment that requires that if parents come forward in an academic setting and say, my faith tells me that this kind of instruction should not happen, that right of the parents to withdraw their parents has got to be not only observed, but followed, okay? That's a big decision. Not only, again, people look at this a lot for the LGBTQIA issues, but I'd offer to you that, again, like the other case, important for things much beyond that, right? You can substitute all sorts of things for it, and once again, there is a majority opinion that is accessible to you and should be digested very much. You, needless to say, once again, have a dissenting 3 members of the Supreme Court, including Sonia Sotomayor, who says, you know what? Number one, this is pretty innocuous. Number two, what we're doing today is threatening the very essence of public education. We want these young people to be exposed to new ideas, including the prospect that there may be their fellow students who have parents who are same-sex in their home. And exposure to new ideas is what academicism is all about. She takes strong exception to what Sam Alito writes about all of this. And then she goes on to say what many other people have commented about. Again, putting aside the LGBTQIA issue, she says, what about the religion? Again, it's got to be a religious base. What about someone who comes forward and says, my religion tells me that the world, the earth, is 6,000 years old. And my religion tells me that this thing that you're teaching in what, anthropology or geology or all sorts of other things called evolution is contrary to my religious beliefs. And so in the public schools, I don't want my son or daughter exposed to that, and for that reason, I want to withdraw my son or daughter from that portion of the instruction that would teach evolution. Sonia Sotomayor talks about this in her dissent. She says, we have gotten petitions and some briefs from some religions that say that they believe strongly that women should not be in the marketplace, they should not be in business, they should not be in commerce and politics and positions of responsibility, that my religion says that women should be at home and they should be raising children. What about books that talk about women in American history who have not stayed at home, who perhaps raised families and other things, but are out there? Can now a family come forward and say, my faith tells me that those stories about women in the marketplace out there, contrary to my religion, and therefore I don't want my student exposed to them? The answer is yes. And it's a result of what the Supreme Court has done, again, just in this past term, that I would offer changes dramatically the way that academics work, right here in Wapaka, around the nation. And I'm quite certain that school boards around the country, if their legal counsel haven't addressed this already, should be thinking about it. Because the Supreme Court has said that, yes, a religious petition in which you say that my religion compels me not to embrace what the public schools are teaching can also lead to a decision that I want my son or daughter withdrawn from that school instruction. You may agree, you may disagree with it. we would all agree that that is a significant change, not only in understanding of First Amendment interpretation, but actually practically in the way that our schools may work in the future. Many other cases out there. I'm going to go through these very, very quickly, just once again to underscore sort of the disagreement among the justices. Here you've got, again, I'm not going to describe this at very great length, you've got, again, a 7-2 majority here in an environmental case involving standing and issues related to corporations in California that may or may not be meeting the exhaust emission standards of the EPA. And along the way, you've got Ketanji Brown Jackson once again saying, I'm worried that the kinds of decisions we're making these days are compromising the reputation of the court. And I raise that to you not to say that she's right or wrong, but just to indicate that's strong language. She's taking on a majority. She's telling Brett Kavanaugh he's dead wrong, and she's articulating it. She's writing it for everyone to read. And Brett Kavanaugh says the same thing about her. Okay, so we've got this acrimony, if you will. Here's another one. You're going to laugh out loud, I hope, at this. But it's a significant case. Remember this case recently in the courts? This involves the administration's $780 million in National Institutes of Health grants. Supreme Court comes back. Do not recommend you read this one. This is very confusing. I still can't keep it straight. Supreme Court basically says, yes, the president has the capacity to cancel $780 million in grants, but at the same time, the underlying policy that this administration has put in effect, that we're going to overturn. Go figure. We can talk about it some other time. But along the way, Ketanji Brown Jackson once again is at it. And just as she is being attacked by the majority, she fires back, and she looks through a comic strip that many of you may know. I wasn't familiar with it before I heard this. And she says it's Calvin and Hobbes, right? And she talks about how what we're doing at the Supreme Court is Calvin ball these days, everybody. And Calvin ball, as she describes, is a sport. You see some of it there, maybe, Calvin and Hobbes, in which there are no rules. You got a ball, you got a bracket, and you just make it up as you go along. She says what we're doing at the Supreme Court is Calvin ball. There are two rules, Calvin ball, which is no rules, and, oh, by the way, the president wins. Those are the two rules. Now, once again, you may agree or disagree with that, but the answer, the takeaway is strong language from Supreme Court justices who are quite literally attacking each other, not physically, but in their language as they issue these decisions of major importance, constitutional importance, that affect your day, not just in academics and not just in the way we engage with each other, but understanding your very status as citizens, right? Let's talk, I'm going to do this very quickly because I want to get to the shadow docket. Let me give you some real quick sense about what else the Supreme Court has done. We talked about those two major cases. Look at the kinds of things among the remaining 57 or 58 cases decided just in recent weeks. Another religious case. Remember, this one comes out of Oklahoma. There's an Oklahoma Catholic, a parochial school. It is a charter school, and they teach the Catholic faith in their education. Can you do that in America? Absolutely. Why? Because the First Amendment says Congress shall make no law affecting the establishment of religion. If you have a private school, you can teach religion. We have that in Wisconsin, as you well know. What happens is that the school in Oklahoma says, we would like to be a part of the public schools, right? We want to be on the umbrella of public monies. And I would say, to their insightful perspective, both the Attorney General and the Governor of Oklahoma say, no, you can't do that. We would be establishing, therefore, inside the classroom, a religion. We can't do that. And so they say no, goes up to the Supreme Court. And because Amy Coney Barrett, our justice, recuses herself, basically says, I shouldn't decide in this case because she knows one of the parties involved, good for her, right? Recusal is a thing where you want the justices to not decide cases where there might be an impression that she could be biased in some way. She says, I'm not participating. It leaves 8 members of the Supreme Court. You can do the math much better than I can. If 4 of them say yes and 4 of them say no, there's no decision, right? And so what happens is it goes back to Oklahoma without a decision from the Supreme Court. The Oklahoma rule applies. The school is not permitted to be a part of the public schools there, but it's coming back at some point. And that issue, this religion focus, We'll come back, certainly. Let's do some other things. Ghost guns, you know what those are. You can apply online now and get the component pieces of a gun. You can assemble it in your basement or at your kitchen table. The question is, can the government regulate the pieces of the gun that come into your home, or is it only a completely completed gun that can be regulated? The Supreme Court says 7-2. Yes, indeed. ATF, alcohol, tobacco, and firearms, can require the placement of serial numbers, do some other things with respect to ghost guns, can be regulated. Look at another one. This is a big deal also. This is a case called Scrametti. A fine is 6-3, again, right down the same line, that legislatures, including Kentucky and Tennessee, can, in fact, in their states, prohibit and make it criminal for healthcare providers, nurses, doctors, others, to provide transitional health care for youth under 18 who are transitioning, undergoing gender transition. They say, the Chief Justice writes the opinion, says, yes, indeed, you can do that lawfully. Again, no small decision, right, in terms of health care, in terms of the power of the states to do what they want to do. And the Chief Justice says basically, this is such a controversial issue. There's so much writing out there about transgender youth issues that we're going to let the legislatures decide. It's also an affirmation of what the state courts can do. Here's a simple one, 9-0. Look at that. They all agreed on something. How wonderful is that? 9-0. All of them agree that if you have something as tragic and horrific as an officer-involved shooting, when you determine whether it's constitutional or not, what should you do? You should decide based upon the totality of the circumstances. You should look at the body camera, the 2 or 3 minutes before the shooting happens and even after it. You shouldn't just look at the 2 or 3 sentences of the shooting itself. I think we'd probably all agree with that, right? They say the same thing. Believe it or not, the Affordable Care Act was back on the docket of the Supreme Court this past year. You know its storied history. You know about these task forces created at the time that what's called Obamacare was established by the Congress. These are the task forces that make determinations about whether or not preventive care, things like diabetes and heart disease and other diseases that can, in fact, in some ways be subject to preventive health care, should those be covered by insurance companies without cost? That's what the task forces do. There's an attack on the task forces, and the Supreme Court says, nope, 6-3, a different 6-3, as you can well imagine, say the task forces are fine. They continue to do their work in America. A few others. Here's gun cases, once again, back before the Supreme Court. Mexico sues the creators, the manufacturers of guns in America. Smith & Wesson says, we've got a problem with crime in Mexico. Our gangs, our cartels are out of control, and you caused it, manufacturers of guns, and so we're suing you in the federal district court. Goes up to the Supreme Court, and look at that, once again, 9-0. They all say, Mexico, sorry, you're out of luck. Go back to Mexico without getting any judgment. Why? And here's the point where you may disagree with this, but the legislature in our nation, the Congress, 20 years ago passed legislation that says that there is a shield for litigation against manufacturers and an attempt to impose civil liability for harms done by the guns. So Mexico is out of luck, as would anyone else be in the United States if you attempt to sue the manufacturers themselves. Here's one you don't want to use if you're running for office. This is basically the question of whether or not states can restrict youth from access to online porn sites. The Supreme Court says, yes, you can do that. That's legitimate. You may think, well, gee, what are the three thinkings? We don't want to have 8-year-olds access. And the three are basically concerned about the long-range implications of a First Amendment restriction, not for the youth, but for adults, and the First Amendment applications that would come from a state that says, we're going to regulate and require you to get permission before you go on site. They're concerned about the future. Probably not a completely inappropriate concern. FCC, much in the news these days, is attempting to and does in fact propose a $9 billion with a B initiative to bring broadband to many of our impoverished cities and towns and counties around the state. And there's a challenge to it in connection with the ways in which it administers its funds. The Supreme Court says, again, look at that. 6-3, they say you can go ahead and issue that, no problem with the way in which the FCC is put together. It does not. Of course, it was decided long before our present focus on the FCC, does not, in fact, raise larger First Amendment issues. It's really about the Constitution of the FCC itself. You got an issue here related to how we do employment discrimination and the ways in which standards inside the federal courts should be applied. Basically, they say everybody, regardless of whether you are a minority or majority population, for race, this happens to be a straight woman who is suing a company that promoted a gay male, and the question is whether or not the same standard should apply to everyone, regardless of gender orientation or sexual orientation, gender identity or sexual orientation. The answer is yeah. Everybody, the same standard should apply. One of these situations where the Supreme Court says, you know what, we can in fact give you a rule to follow. Lower courts, 9-0, they're all in agreement there. And finally, with respect to vaping, can the FDA regulate advertising for vaping companies? The answer is, once again, 9-0. You bet they can, especially when the advertising is geared toward young people with attractive flavors like fruit and mint and menthol and candy and that sort of thing. Right? That's a lot. There are 45 other cases like that. I want to give you some sense of the wild ways in which the Supreme Court has done a lot of things. I'm going to skip over this just in the interest of time, talk to you about this later. Just know as well, the state legislatures also have a role to play these days. There's some major things going on. There's some things in Texas. This has to do with the LGBT issues there. And also in Iowa, just across our border here, same kind of thing. Want to underscore again, regardless of how you feel about the legislation itself, making major decisions. And I would offer to you again that whether you appreciate this or not, the particular things that Texas and Iowa and other states are doing when it comes to LGBT rights, the answer, of course, is you've got legislatures who are doing this, right? Regardless of whether you like it or not, that's what they are. We'll spend some other time talking about it. And finally, almost finally, let's get to the other big topic of the evening. You'll be very proud of me. It took me hours to find this picture of the Supreme Court in shadow. Get it, right? The shadow docket. I almost didn't make it up here because I was so focused on this. What is this all about? And it's serious, and I do not mean, once again, just like class actions, to be flip about this at all. All the cases we talked about, those 12 or 15 I just talked about, the case involving Maryland and the books there, the case involving the 14th Amendment, all of those are on what's called the merits docket. And what happens there? Again, the Supreme Court looks at the lower courts, those district courts, the appellate courts, and it says that we're going to take those cases and we're going to require the lawyers to write briefs. Lawyers like being heard, right? Can you imagine that? And they write briefs and they appear before the Supreme Court for oral arguments, those sketches that we have seen, and it goes through a lot. And in a couple of weeks when they start to hear from some of on these cases, you will hear about oral arguments in cases that will be decided then in June of next year, right? They cogitate on them for a long time. They're subject to, again, the fights that I talked about that probably do happen behind closed doors among the justices before they get to a result that probably dissatisfies everybody in some way. That's what's called the merits docket. It goes through this process of deliberation. And again, I've said it repeatedly, whether you like it or not, the Supreme Court, as a result of that process, produces a decision. And I've got, well, I won't show all of it, but suffice to say, here is one of them, for example, that the Supreme Court issued not too long ago. It's basically this big, and they provide you with all kinds of information. They explain why it is they're coming to the conclusion that you do have a right to opt your children out. They come to the conclusion that indeed the 14th Amendment should be applied this way or that way. And you can hear everybody describe their positions. And it is transparent, it is translucent, you can use whatever word you want. That's the merits docket. What has happened recently, and it goes back even before this present administration, is the Supreme Court deciding cases without that process. Applications made principally by the administration, not just this one, but previous administrations as well, seeking emergency relief. While the underlying cases, the merits docket, is going forward, coming to the Supreme Court and saying, we can't wait. This is an emergency, and so Supreme Court justices decide right now whether or not the president can do what he, maybe one day she, wants to do. And as you'll see with the numbers in just a little while here, in more than 20 cases or so, the Supreme Court says, yes, go ahead. And more importantly, does it without the benefit of any of that deliberative action, the briefing, the oral arguments, the cogitation, and does it typically in a one-sentence order, or maybe a couple paragraphs that do not describe what's going on here. And again, typically a split court, and the question also raised, are these emergencies or not? And we've got justices, again, on all sides of this. Let me give you some sense of the statistics here. You recognize both of them. Both of those people used to be presidents of the United States of America. The one at the top, his name is George Bush. The one at the bottom, his name is Barack Obama. During the 16 years in which those two presidents occupied the White House, the administrations, through the Department of Justice, made applications, emergency applications to the Supreme Court. Decide right now, we can't wait. Don't give this all the deliberative review that we otherwise would give it a whopping 8 times in 16 years. The Supreme Court granted it a whopping 4 times, 16 years. During the first term, again, not being critical of this process necessarily, but giving you some sense of the dramatic change in the way the Supreme Court is deciding things. In the current president's the previous term, he applied for emergency relief 40 times, and more than half of those times the Supreme Court granted it. In the last 8 months, the president has applied for emergency applications, emergency relief, 23 times. Okay? And in the great majority of those, the Supreme Court has said yes, and has said that the litigation, even while it goes on at the lower courts, the president can do all kinds of things as set forth in principally his executive orders. Let me give you some sense of what those are like. These are the kinds of decisions made in our nation. Again, you may agree or disagree with them, but the point of this is the process, which I would offer everyone should be concerned about. In 2 different cases, the president rescinded all sorts of things related to immigrants in this country, and 2 different sets of immigration personnel, people, both under the Bush administration, the Obama administration, the Biden administration, about 800,000 people. President Trump terminates all of that. There is challenge to that. The underlying litigation is still going on to this day. The president goes to the Supreme Court and says, even while those cases are not resolved, give me permission to deport 800,000 people. And the Supreme Court, one-sentence order says, yes, you may go ahead and do that. Here's another big one, transgender folks in the military. It is a very small percentage of our military forces that are transgender in demographic. And along the way, the president, again, early on says we are going to eliminate transgender personnel from the military. Challenges to that. Some of those are being resolved. Many of them are not. Goes to the Supreme Court and says it is an emergency to terminate their postures, their positions in the military. And the Supreme Court says yes. And today, we have no more transgender military folks in our military. Major decisions having to do with agencies, National Labor Relations Board, Union, Merit System Protection Board, and yes, indeed, just a couple of hours ago, the Supreme Court said that the president can, in fact, terminate the employment of one of the board members, the commissioners of the Federal Trade Commission. This just happened a couple of hours ago, okay? And again, what brings all that together? Decisions challenging his termination of these individuals, appointed by presidents on all sides of the political aisle, terminating them. Litigation goes on challenging that. And the result is that the Supreme Court says, yes, you may terminate those folks. 1 or 2 sentences. The order of this afternoon appears to be one sentence, and tells this commissioner, you have seen her in the news a lot, that she is no longer a part of the Federal Trade Commission. The reason why that is significant is, once again, for these agencies, and there are more of them, when you strip those people of their positions in this way, you reduce the quorum, and they cannot make decisions, right? And so the president can appoint new people to this, but you're basically saying that the FTC, the NLRB, Merit Systems Protection Board, can no longer have the authority to act in the way that it is. Again, you may agree or disagree with that, but the decision is being made without transparency, without this exposition before the Supreme Court that you're getting lower. And here's the big one, of course, criminal deportations, lots and lots of cases, not just involving Abrego Garcia in Maryland and in Tennessee. Many, many decisions here of the Supreme Court saying that the president, again, without this exposition, as the litigation goes on in lower courts, can do this, can deport people to nations that are not of their origin, to do other things without that full process. Let me do a few more of them. I'm going to go very quickly here. This is one that, regardless of how you feel about all these other issues, that I would offer to everybody in this room. It's a concern to me as well. You know well about the Musk team and their access to aspects of government. You know that the Elon Musk team did seek permission to go to the Social Security Administration, get access to information. I happened to work for 30 years and was always very much attuned to the fact that that information, your information, as a United States attorney, I couldn't get it, right? Nor should I get it. Why? Because when it was established, the notion of your private your number, but also your medical information, healthcare conditions, which are also a part of that, cannot be accessed by people who don't have a need to know, okay? And that has been the law affirmed by the Supreme Court, established by the Congress. The Musk team says we would like access to this. It's challenged, and the Supreme Court says yes. This is the one sentence from the Chief Justice. The Social Security may afford members of the Musk group access to the agency records for those members to do their work. That's all you get from the Supreme Court. And so tonight, you should know that people who are on this team have access to your numbers and your medical information without the kind of exposition that you would otherwise get when this is challenged normally. Here's another one. This is the big one having to do with generally the reduction in force across the government. Again, you may agree with that. You may say, yes, the president is trying to bring together these notions that we need to be leaner, and as a policy matter, you may in fact embrace that. He basically says, I want all the executive agencies around the cabinet and beyond to reduce their force. And the Supreme Court, again, even while these are being challenged with respect to many agencies, Supreme Court says, two sentences, yes, you may go ahead and fire people, reduce the workforces of these agencies, again, without the litigation and without the exposition. Ketanji Brown Jackson then once again opposes this with great vituperative language. Here's another example of that. The Department of Education, you know this well. 4,000 people in Washington, D.C., at challenge to whether or not the president, civil servants subject to the Merit Systems Protection Board, which we saw a little bit before, civil servants whose jobs are protected, not from everything, but they're not at-will employees. You have to be fired, if at all, for cause. The president says, I'm going to fire 1,000 of the 4,000 people. They challenge that in court. And it comes up through the courts, and you've got judges, both at district court level and appellate court level, who are saying, yes, indeed, you cannot do this without getting what? Congressional authorization. Why? Because the Congress created the Department of Education, and only the Congress can basically remove the authority to hire and fire these people. Comes to the Supreme Court, and the Supreme Court says, yes, you can do that, and you can do it immediately. Once again, you get the three dissenters saying the impact of this will be dramatic. Here's the Consumer Product Safety Commission for your children, your grandchildren, your great-grandchildren. These are the folks who not only take care that the toys that you step on when you're visiting them and wrench your ankle, but also those household items like your refrigerator, that they review all that. Consumer Product Safety Commission. You know what you do. You see their emblems all the time. And the president decides that he wants to fire 3 members of the commission that makes these major determinations about what can and cannot be done in its congressional authorization. Consumer Product Safety Commission, for what it's worth, like these other agencies, is not a cabinet level position, okay? It's an independent agency created by Congress. President nonetheless fires 3 of the members, and the Supreme Court says, yes, you can do that, and therefore robs them of the capacity to make future decisions. Once again, you get a strong opposition from the 3 members of the Supreme Court. And the majority has negated Congress's choice to establish these agencies as independent by doing what they're doing. They're also arguing As Sonia Sotomayor does, go home tonight, read the information about this. She is also decrying the fact that the FTC commissioner, same kind of thing, that the decisions are being made without all of this. Here's another one that I would offer again. My bias, of course, is law enforcement. This is a federal district court judge. I know this is highly controversial. You know what's going on in Los Angeles, right? Many, many things we can talk about. But the upshot is that this woman, she is a federal district court judge in the Central District of California. She is one of those individual judges we talked about before. And there's a lawsuit filed alleging that the domestic and the military forces that are in Los Angeles right now are arresting people based upon skin color and based upon where they're standing and where their jobs are. And she has a hearing. This is not a judge who knee-jerk reaction to it. She has a hearing, lasts about a week, and she has testimony from people. The practice is defended by the Department of Justice, and in the end, you know what she does? She reaffirms what has been the law of the United States of America for all of our lives and beyond. It's the law that I appropriately, wonderfully embraced every single day of my term as U.S. Attorney and as an Assistant United States Attorney, and that is, when you go out on the streets of Waupaca tonight, if you are approached by law enforcement of any kind, the only standard, the only way in which that person can detain you or arrest you is if she or he has what? A reasonable suspicion to believe that you have engaged in the law. And that's been affirmed, again, by Supreme Courts, by Congress, by presidents of all parties, right? Reasonable suspicion. And that's what she articulates in her district court order. 14 days ago, 2 weeks ago today, the United States Supreme Court, without any exposition, without any description, says that Judge Frimpong's order is vacated and overruled. And I will tell you tonight that if I had to teach law enforcement, as I often did and still do, what the law is about arrests and detentions in America today, if you ask me to do that tomorrow morning, I don't know what I would tell law enforcement officers tonight, because of the Supreme Court's decision. And yes, I live in a great country where I can stand in front of you in an area that's incredibly important to me. I had this incredible responsibility every single day as a U.S. Attorney for 7 years to ensure that the rights of every single person are enforced, and the defendants who may have done terrible things in violation of federal law are nonetheless given due process. And when I see this sort of thing, that you have rescinded the fundamental notion that's animated our nation and law enforcement for 100 years or more, and it was rescinded 2 weeks ago, I'm very concerned about what the Supreme Court is doing substantively. Here's a positive one. I promised some positive things, right? This is the 8th Circuit. They're just to, you can see where we are there. These are the states just to the west of us. And a little bit of history on this. Voting Rights Act. Basically, the Voting Rights Act, since the time it was enacted in the mid-1960s, says that anybody can enforce it. You can go in, government can go in and enforce violations of your right to vote, right? And the great majority of cases have been brought by private citizens like you. Government does a lot of that. I did some of those cases, the great majority of them by the government. 8th Circuit says that only the government, only the Justice Department, only U.S. attorneys can prosecute these kinds of cases, okay? And that is contrary, again, to not only what the Voting Rights Act says, but what the Supreme Court has said, what the Congress has meant. And to its credit, I would offer to you tonight, the Supreme Court, in its emergency docket, again, doesn't tell me why it does this. It's the same rule applied in the opposite direction. Tells me, no, 8th Circuit, you're wrong. You gotta let the tribes, in this case, bring their lawsuit, not deciding on the merits of it, but everybody gets access to the Voting Rights Act into courts. Again, emergency docket, you may approve of the result here. You may approve of the result in those other areas, but the reality is here, as in the other situations, I have no idea why my Supreme Court said no to this, to the 8th Circuit. I would like to know that as we go forward. What's happening and again, beginning in 2 weeks from today, remember these names. Huge case in Calais, remember this? This is a case coming out of Louisiana, just like we've had here in Wisconsin, involving line drawing congressional districts. The case was up before the Supreme Court, and very curiously, they decided not to decide it. They kicked it into the coming term, again, starting in 2 weeks from today, and so we're going to revisit it. Calais may be the case in which the Supreme Court finds, again, this is on the merits docket, to its credit, they may find that the Voting Rights Act of 1965 is unconstitutional. It's before the Supreme Court coming up in this term. Here's a case involving their again, issues of LGBT issues. This is transgender athletes, a case called Hecox. That's before the Supreme Court. There's another case, many other cases out there involving everything from campaign finance. There's another religious case involving a prisoner who had his dreadlocks cut in federal prison. The question is whether or not his religious rights were affected by this. All kinds of things out there. Here is a case coming out of Colorado once again. This has to do with conversion therapy, okay? You know what that is, right? The question of whether or not states can prohibit conversion therapy, as Colorado did, it's before the Supreme Court in this coming term. Here's some of the other things. As I said, there's a death penalty case in the current docket coming up. There's an internet case involving whether or not your provider is engaging in copyright infringement by giving you access to all kinds of things that have intellectual property protections. And yes, there's a derivative abortion case again about the donors to abortion clinics. What is my point of telling you all of that? Regardless of how you feel about the dispositions, these are big ticket issues, are they not? And they're being decided by the United States Supreme Court coming up right now. And here's the other big one, that the Supreme Court has also granted review of tariffs. You've got two courts out there, international trade, and an appeals court called the Federal Circuit, that have both determined that under the Constitution, it's only the Congress that can impose tariffs. And this particular law that the president has invoked, called the International Emergency Economic Powers Act, you know it. It's the IEEPA. You talk about it all the time, I know. that law does not give the president the capacity to do what he has been doing for the last 8 months. That's what the state of the law is. The Supreme Court, probably appropriately, has put this on the merits docket and said, we'll resolve this. This is a huge case, right? It's a huge constitutional case, and the Supreme Court is going to be deciding this sometime between now and, if you invite me back again next year, between that time as well. So what are the big takeaways here? And then we'll emergency application process. I hope you take what I have said, not so much with a grain of salt, but in the seriousness and the impartial way that I presented. It's an issue for everyone across the board in terms of the transparency of our judiciary. This rancor I've talked to you about, there are other instances of it. It's probably the least important thing, but they're fighting viciously these days. This is probably the big one. It's why it's highlighted. A year ago, once again, the Supreme Court said, yes, presidents can be immune from prosecution for crimes in the office. And the Chief Justice also went on to say that the president needs to be nimble and strong and muscular and deft and quick and do all kinds of things. It's in the first 5 pages of that order. And I would offer to you, that was a year ago, that was July 1 of 2024, and I would offer to you, regardless of how you feel about the executive orders issued by the president, that it's that commission that we are now living under, because it is the law of the land. And it is joined now by this bookend, which we started with an hour or so ago, this issue that now, when it comes to addressing alleged unconstitutional acts of the president, again, subject to review by courts, you can't get nationwide injunctions to stop those things from happening. And I would offer to you that in combination with those two decisions, you may agree with them, you may not agree with them. The impact of them, which all of us should agree on, is it establishes in the executive branch a huge amount of authority. Whoever occupies the White House now and in the future has great authority that a year or so ago the president did not have. And then again, these great focuses upon religion. You will see a lot more of that in the coming term. Education issues, we saw that. Environmental issues, lots of civil and human rights issues as well. And so what is the point of all this? Well, again, regardless of what your political persuasion may be, 407 days from now, you have the capacity to address some of these issues. You're going to go to the polls, right? You're going to go to polls a lot in 2026 here in the state of Wisconsin. And 467 days from today, the 120th Congress of the United States of America is going to be sworn in Washington, D.C. What haven't we talked about a lot tonight? The United States Congress, right? The power of the Supreme Court, the power of the executive. And I would offer to you as a thought piece as we begin to conclude here, that you ask yourself, what is my legislature doing? Why? Because the legislature, they're your elected representatives. I mean, you go to polls in 407 days from now. Those are the folks I should be offer to you that under the Constitution, James Madison, George Mason, the contemplation was that they would be deciding these issues about education and LGBT rights and commerce and, yes, indeed, religion, all these kinds of things. We have got between a president who is issuing executive orders on those things and a Supreme Court that is authorizing him to do those things in many ways, a combination that basically excludes that place, and that is the legislature. And when you go, again, I'm not advocating for Democrats or Republicans. I would offer to you that maybe you propose to those candidates here in Waupaca County and around as we elect congressmen and women in this state, as you propose and talk with them, that they go to the Congress with the notion of reestablishing the constitutional balance that Republicans and Democrats and independents have always embraced, which is authority there. They represent you, not 9 people on the Supreme Court who are doing these things because of the absence of action by the legislature, and not by a presidency, which I also respect. I worked under 9 different attorneys general. Most of them are Republicans, and I proudly worked under all of them. This is not a political issue, but it is an issue about the authorities presented in the Congress, which I would offer to you as a principal thesis tonight, has been jarred. And tonight, as we get together on September 22nd, that balance is no longer in place. That is not a happy way to end, but it's also an invocation to action. Again, regardless of how you feel about politics and partisan things in America, those are the kinds of things that should animate your advocacy. I thank you so very much for this time with you, Danette. I think we got a few minutes here, and I'll stick around afterwards as well. Thank you so very much.
The one thing that I noticed too is that everything is becoming too politicized.
Yes, absolutely. Yep.
We need
Right.
to change that.
Absolutely, right. And there are ways in which that can be done, again, through the legislature, right? Not perfectly. You'll never get it completely erased. There are things that an active legislature can do, and both sides of the Supreme Court have talked about those things in some of their dissents and some of their major opinions.
Question over here.
Yes, please.
You were saying that as the issues went through the courts,
Yes,
the Supreme Court now in these emergency has decided, okay, this is so.
right.
Are those cases now done?
Right.
Or do they continue to work through the process and could come before the chiefs again?
Outstanding question. You should be teaching this and be talking up here. The answer is because they are emergency docket decisions, they only are in place for as long as the underlying litigation is unresolved. And so the point of your question in part is this. If indeed the Supreme Court permits the firings of the FTC authorities, permits the termination of funds for academic institutions for overseas support, and it turns out at the end of all that the appeals court, and maybe even the Supreme Court says, oops, that was wrong. The president does not have the authority. Decisions have been made, right? The monies are no longer there, that people have been terminated, and that's the other reason why this emergency docket is so concerning. You should know the Supreme Court is not obliged to take any of these cases. They can simply say, let them proceed up to the regular process. We'll review them on the merits docket, but that's the consequence. But they do not stay in place until one day the Supreme Court makes that decision.
Time is now 7:50 p.m. and the library will be closing in 10 minutes.
All right.
We're going to keep
Over to the main desk.
going for
Visiting
10
us
minutes
today, we will
and stay a
reopen
little
tomorrow
late.
at 9 a.m.
And we'll all run up the stairs together, right?
Real
Please.
quick question. This is it's really the attacks on the institutions of our government. And I was in the National Guard for 28 years. You know, we basically were malicious, so we took care of national disasters.
Yes.
And we federalized.
Right.
Okay, we sent the National Guard to L.A. Next thing they did is we found out they were armed. The next thing they did is now they're a police force in the D.C. That totally, it's a creeping.
Right.
My question is, next week, I believe the federal government is going to be unfunded.
Right.
With no talk about this at all.
12 o'clock midnight.
Well, but that
Tick-tock.
to me is an emergency. Is that going to open
Right.
the door for?
Right? And again, but how much time do we have, right? Exactly. It's a huge issue. And I'll pull it apart very quickly. Two things, great concerns. about the mixing of domestic law enforcement and military forces. I was in Iraq for 2.5 years and proudly served again under George Bush and a Republican Attorney General there. And I saw, as many of you have, and you did, sir, as well, how a military operates. Out of necessity, it's a war, right? That's a different function than law enforcement, domestic law enforcement out here in the streets of Waupaca. Second issue, if in fact the Congress doesn't act and gets some kind of a budget to the president for him to sign in just tick-tock, I think it's a little bit more than a week or so, the government goes unfunded and shuts down for the most part. I worked through 4 different times when presidents, Congress has failed to get a budget in place. Let me tell you, as you know well, as everybody knows well, it is a bad situation when you send people home and the functions of the Department of Justice are not being done in court on a regular basis. That's a bipartisan embarrassment, right? And somehow that's got to be overcome. But, again, does a president have the capacity to order in an unconstitutional way that government remains open? Maybe so. Is that a true emergency? Maybe it is. Maybe it is. We don't know. Your question is all important. Please.
Administrative warrants?
Yes. Yes, I'm sorry. Yes, yeah.
Administrative warrants for subpoenas?
Yes, so administrative warrants, all kinds of things out there. The question is, are administrative warrants legal? The answer is yes, yes, but for limited purposes, right? There's a difference between going to a federal district court judge, as I did on a regular basis, and say, here is probable cause to believe that in Jim Santel's home there is proof of a crime, and having a judge determine whether or not I'm right or wrong about that, and granting that motion to search or to seize something, and an administrative warrant which does not have that predicate information. Judges still have to provide some information for it, but it's not the in-depth review, and therefore subject to greater scrutiny when it comes to coming up. And so the answer is, right? That's one of the concerns, and that's why Judge Frimpong was all over that kind of thing. She said, we can't be doing that, right? Please, other questions? Yes, please.
Final question?
Please, yes.
Thank you for a fantastic, detailed presentation.
Thank you very much.
This is coming to you from an immigrant, born in Hungary during World War II, a citizen of Venezuela when I came here as an immigrant in '58, okay? What I have noticed in all of these ongoings is that the law is never being followed, constitutional or otherwise. And my question is this. Fabulous. I came here and pledged allegiance to the Constitution, not to a person.
Right,
okay?
right.
Who enforces this stuff?
You all heard the question. And the answer should be, again, I worked for 30 years for many different attorneys general, different focuses. The United States Department of Justice, they're your lawyers who go in on behalf of you and other people in all these areas, including immigration issues. Who did I work for? I did not work for Barack Obama. I did not work for George Bush. I did not work for Joe Biden at all. I worked for the people of the United States of America, and when I stood up in court, I said I represent the United States, and by that I meant you. You need to know this Attorney General has said that Assistant U.S. attorneys work for the president. That is a dramatic change in what has happened. And I would tell you, I would give you a different answer if I was here 10 months ago. I believe that the United States Department of Justice has a great power and capacity and obligation to represent you in those kinds of things, even individually, even in the civil rights area, the Voting Rights Act, other things, immigration. And if we can no longer count on the Department of Justice to be that person who represents you, but instead represents a president, that, again, not only a dramatic change in how we do things, but it, again, forgive me, abandons the fundamental precepts of our Constitution. I wish I could be happier about that. And you need to do, again, the advocacy. Here's the last thing I will say. If you're concerned about that, you write a letter not only to the people who are maybe making decisions, but also write a letter to the Judge Frimpongs of the world, who may be doing the right things out there if you feel strongly about that. Let the people know, regardless of what your politics are, what areas you support them in, and say, do more of that. They can't respond to you, but write those letters. That's equally important as a part of the advocacy. That's First Amendment stuff. That's the other reason why we're gathered here tonight. I thank you so very much.